So in Commonwealth versus Richardson, we are looking at a way of showing simple assault. And in this case, the defendant punched an officer. And the court looks at two different prongs of proving simple assault. As we looked at in the video relating to simple assault, there are two different ways you can go about showing even the very first prong of the simple assault statute. One is to show that you intentionally, knowingly, or recklessly caused bodily injury. And that begs the question of what exactly is bodily injury? Because one of the things that the defendant argues in this case is that he didn't cause bodily injury. That in this case, what happened to the officer didn't really amount to bodily injury. And the court says, no, 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 that's not the case. The officer's glasses were broken from the punch. The officer was stumbled backwards as a result of the punch, and the officer had pain for a few days thereafter. That's enough to show bodily injury. Now, the court contrasts this with the sibling feud and with the violent dancing that caused the woman to have pain. And in each one of those cases, I don't know that we can really glean a lot from the amount of pain that was involved or the injury that was involved. In those cases, the court really seems to be carving exceptions for social, engagements or the nature of squabbles within families. Courts don't want to take, mild brother sisterly fights to juvenile court. With the child example, and I don't have any idea what's going on with the violent dancing. I don't know what violent dancing might be. But in any event, the court is saying if there is pain, and there was another case involving punching, if there's pain involved, then that's bodily injury. If something happens to your body that causes you to experience things you don't want to experience, and they're uncomfortable, and would be uncomfortable in any setting, whether consensual or not, and this was something that the defendant did intentionally, knowingly, or recklessly to cause this to happen to you, then unless there's some kind of consent argument, and I kind of think that, like, certainly the dancing one and the case involving the family squabble, it's almost like you consent to certain indignities within a family. So if you're on a subway, for instance, and someone bangs into you and knocks your elbow, that might be perhaps they could have been more careful about this, and so it wouldn't rise to the level of recklessness. But then there's actually another thing that's going on, even if the court doesn't talk about it expressly. There's something like consent, that you've consented to being bumped into when you're on the subway. Now, people shouldn't be on the subway in a reckless manner that causes you to be injured. But you wonder with the dancing example if that's not a consensual example. So if you're in a boxing ring and someone hits you, you've consented to be hit. So you wonder, the dancing example in the court's analysis, is a strange case. I wouldn't glean too much from that particular case. If someone commits an act that causes you pain as a result of something that person does intentionally, knowingly, or recklessly, and a punch certainly qualifies as such. But in this case, the appellate court says, no, look, the trial court didn't actually make its ruling on the basis of bodily injury. It made its ruling on the basis of the intent to cause pain, the intent to cause bodily injury. And in this case, what are we looking at? What are we looking at in this case? We look at the defendant's argument that, look, he was in grief, he had some angst that day, and so therefore he did not intend to cause pain to this officer. The court says that's just not the case, because he yells at the officers, "Get the hell out of here," or something like that, before he punched him. Did he evince a desire to cause pain, and then the punch itself wasn't accidental? It wasn't like someone grabbed his arm and threw it. So it's kind of like use of a deadly weapon. We can infer certain things that you desire from what you use. If you use a gun and shoot it at somebody's heart, we assume you probably intended to kill the person. If you throw a punch at someone, we assume you intended to cause pain. Even if you didn't, let's say the guy steps out of the way. Let's say he blocks it or something. And clearly I'm not a fighter. I'm sure that's, not a great way to block a punch, at least not the way I did it. But in any event, this was looked at, or this was analyzed in the lower court on the basis of the intent to cause pain, not the actual cause of pain. And there's evidence here from both the statement and from the defendant's action that there was in fact intent.